Hey folks, how's it going? So let's go over a Seattle Times article written January 8th, 2025. Give credit to Seattle Times staff reporter David Croman, who does a lot of writing on the gig economy in Seattle. Headlines: Judge denies motion from Uber and Instacart. Late December, Uber and Instacart tried blocking this law from going into effect. It was late December they tried blocking this from going into effect. New law: app-based delivery companies will need more justification to boot drivers. A new law regulating when app-based delivery companies may deactivate drivers went into effect in Seattle on January 1st after a federal judge denied a motion from Uber and Instacart to block it. The law restricts the company's ability to boot delivery drivers and couriers from their platforms without more extensive notice and justification. So now they have to give a 14-day notice to the driver that's deactivated and the true circumstances around the deactivation. Facts, not assumptions. And requires them to provide more opportunities for drivers to understand and appeal the decision. A fair process, it sounds like. Passed in 2023, but delayed in its implementation, the law's purpose was one piece of a larger effort by a previous city council and labor-backed advocacy groups to regulate the so-called gig economy. So the city council in Seattle has changed quite a bit from when they were pushing these laws: the pay-up law, the deactivation law, the paid sick and safe time law. While the law was approved more than a year ago, Uber sued to stop it less than 2 weeks before its start date. Late December, they tried stopping this just a few weeks ago. The company argued it posed a safety risk for customers. So the company's supposedly worried that the information given to the drivers is too much, and maybe some of the drivers may retaliate against the customer that filed the complaint, and violated the company's First, Fourth, and 14th Amendment rights under the U.S. Constitution. Instacart later joined the case to block this law. District Court Judge Marcia Peckman denied the company's request for a temporary restraining order, concluding all of their arguments were likely to fail upon further examination. Companies like Uber or Instacart sometimes temporarily or permanently bar drivers, as we call it, deactivate drivers, from their platforms if background checks reveal the drivers have past traffic infractions, their ratings dip too low. What's the deactivation policy on DoorDash? Below 4.2 customer rating. They refuse too many rides, decline, or fail to upload certain documents. Uber, you got to upload your insurance and your driver's license. Some workers complained. However, they had been denied access for arbitrary reasons they did not fully understand. Those are hard to understand, prompting labor groups to push the council to action. New law requires companies to write a reasonable policy for when and why drivers will be deactivated. It's a 14-day notice to the deactivated driver and true circumstances around the deactivation, not assumptions. Under that policy, the company should not deactivate drivers for failing to drive enough hours, falling below a minimum customer rating, or turning down ride offers. And deactivation should not be based on the results of a background check or driver record. Interesting. And as we know out here in this community, there's a lot of people, worried about tickets and background checks and stuff like that. Interesting. Except in egregious circumstances, the law states. The law also requires the companies conduct a fair and objective investigation and provide 14 days notice before deactivating a driver, except in certain circumstances. Drivers should also be provided with the records justifying their deactivation and be given the chance to contest the decision. The records, full transparency given to the driver for the deactivation. And as we know about here, lack of transparency is the case in most deactivations. Finally, the companies are required to turn over internal data. That's interesting because these companies never turn over any data on how frequently and why they kick drivers off from their platforms. In the case first filed by Uber last month, the company argued Seattle should not be allowed to compel it to write a policy it did not agree with. The law, the company argued, offloads the city's vision of what amounts to an unwarranted deactivation and the harmful effects that vision is likely to bring about onto companies like Uber by forcing them to announce policies that espouse the city's views as if they were the company's own. By restricting their ability to deactivate drivers, the city was also forcing the companies to associate with drivers it may believe are unsafe, unqualified to use their platform, the lawsuit said. So, forcing the company to associate with drivers it may believe. See, when it could be just a false complaint or accusation against the driver. Now, so the drivers are going to have to be given the true facts. Above all, an Uber spokesman said the law posed a safety risk for customers. So they're worried by giving out the circumstances around the deactivation, the customer circumstances. Uber's concerned that maybe drivers may retaliate. But if your job is important, you're not going to retaliate. Peckman disagreed. The city is not regulating speech, she said, but instead imposing standard regulation on operation by the companies. They are free to voice their displeasure and disagreement with the law, even as they are forced to follow its parameters. The court finds that the ordinance's requirements do little more than regulate conduct without any significant impact on speech or expression, she wrote. In a statement, the Uber spokesman called that ruling disappointing. We are carefully evaluating our legal options and next steps and remain committed to working with stakeholders toward a resolution that best serves carriers, consumers, merchants, the spokesperson said. Since the law's passage, the Seattle City Council has taken a turn away from the first in the nation labor laws. So Seattle was the first in the nation to push these new labor laws, the pay up law, the $26.40 active time before tips, the paid sick and safe time law, and this deactivation law. Now, these companies have all paid fines by not following these laws. Since the law's passage, now Council President Sarah Nelson was one of the 2 no votes on the law at the time. She's since been joined by 6 new colleagues. So the Seattle City Council has definitely changed from when they were pushing these labor laws. Whether the council will do anything to change the deactivation law however, is a different story. Nelson sought to rewrite a different law guaranteeing delivery drivers a minimum wage. So they were looking at changing the pay-up law, but it stalled out and nothing's been done. But the effort stalled indefinitely. That's going to do it, folks. So in Seattle, Uber and the gig companies are going to have to give transparency when it comes to deactivation, not just leaving a driver in the dark.